Hello, everyone. Thank you for joining our webinar. My name is Meredith. I work with Allison Schaberg at Consolidated Planning Group, and I'm happy to introduce today's speaker as Melissa Donovan. She is a special needs attorney with Texas Trust Law, and I'm going to remain for the webinar and look at the chat and interrupt Melissa from time to time with a question that you put in the chat. Everyone will receive the slides, the recording, and Melissa's contact info after this webinar, so you don't need to write things down. And Melissa, thank you so much. I'm going to go ahead and turn this over to you.
Thank you, Meredith. So thank you all for joining us today. We're going to be talking about guardianship and some alternatives to guardianship. I know that a few of you had sent in some questions prior to the webinar today that we may be able to get to. I know some of those questions were guardianship related and some were not, and that's okay. If we have time to get through all of those, we will. But my name is Melissa Donovan. I'm a certified elder law attorney in Austin, Texas with Texas Trust Law. Texas Trust Law is pretty well known in the area as an estate planning firm. We've been in business for almost 30 years, but I focus my practice on special needs planning, guardianships, elder law, Medicaid planning, etc. So I will ask that you bear with me today. My throat's not doing so great, so we're going to do the best we can to get through, but I want to make sure that you're getting some good information. All the allergies are hitting everybody around here this time of year. But as an attorney, we always have to do a little disclaimer as kind of supposed. But this is just that you understand that even though I'm an attorney giving you some information, this is all just meant to be educational in nature. None of this is actual personal legal advice particular to you. That can only be provided in a one-on-one setting with an attorney that you speak to confidentially. But without further ado, let's kind of dive in. And the reason that I really particularly enjoy doing this webinar in particular is I find that there are a lot of people on both sides of the coin that I meet with or talk to that either are convinced they need a guardianship when they really don't, or don't know anything about guardianship and really do need it. So it's a really good topic for you to be learning about. And if you are here well before your child is turning 18, then kudos, because you're doing some great pre-work in preparing yourself for what the future could hold. But on that note, let's kind of walk through a couple of basics. And you might be sitting here asking, well, what is guardianship? Why do I need it? What is this all about? Guardianship is a legal procedure whereby you are taking control of another individual's decision making. And the way that I describe it to a lot of my clients, because I do a lot of guardianship for parents who have children with special needs who are about to be turning 18, they are turning 18. And the issue is that you've been doing all of these things for your kids up until this point. You've been making the doctor's appointments, talking to the school, helping to make decisions with the doctor. And then the moment they turn 18, sometimes it can be a little jarring to realize, like, oh my goodness, people are not talking to me anymore. People are asking for information. What do I do? And in some situations, guardianship is what is necessary. And we'll go through different types of guardianship and what all is involved in getting it. But there are what we refer to as lesser restrictive alternatives, which is what it sounds like, essentially. There are other options that are available to more people than you think to avoid the need to go to court and actually obtain a guardianship for your child. So when we talk about having a child that does have some disabilities and some special needs, the guardianship conversation we are having today is one piece of a bigger puzzle. And I love this visual because there's so much that goes into, as probably most of you on this meeting today understand already, so much that goes into raising a child with special needs. You've got to think about, yes, eventually guardianship. We think about Social Security and Medicaid. We think about your estate planning. And we think about, like I said, these alternatives to guardianship. Can we do a power of attorney for the child? Can we do supported decision-making agreements? But then there's a host of other things that you have to worry about day to day. The doctors, the teachers, the counselors, the therapists. We kind of lump that into your support team, family members, and how they coordinate into things. It's a big picture, and it's a lot to coordinate. And you're kind of like the project manager of all of this, just trying to figure it all out. So there are a lot of webinars that are available through the Consolidated Planning YouTube channel and on their website. And it goes through all of them, a number of these different things. So we also have some on our firm's website as well that you can look out to. So why guardianship? Okay, so let's kind of have that conversation here. What is the reason that we need it? The reason is that what I was getting at earlier, as soon as your child turns 18, legally they are an adult. So we can all have personal conversations as to whether or not 18-year-olds are adults in the eyes of us as a personal thing, but legally they are, and they have the right to make their own decisions and be in control of their own decision making. In certain situations, some people are not capable of doing that as clearly or as easily as other people. And that's why we have to have these conversations about guardianship. And just like with many things, there's a spectrum. With some individuals that I see and talk to, it is incredibly clear that a guardianship is necessary because we have no other alternative. The person doesn't have enough capacity to understand what it means to sign a power of attorney or a HIPAA authorization. So you can't utilize those other tools when someone has such a low capacity level that they can't actually understand what it is to sign those. And hence, we may end up in a situation with a guardianship. But all of this comes down to the way I explain it to my clients is you, when your child turns 18, are getting guardianship to continue being able to be the parent that you have been for the last 18 years. And that's a very simplistic way to look at it, but it really is, when we're talking about certain types of guardianship, exactly what you're doing. So what are the things that we want to consider when we're thinking about guardianship? First thing, what's the concern? That's the simple one. That's your baseline question. What is my child's condition? What are their capabilities? What can they do? What can they not do? What do the doctors say? So you want to think about what that disability is. And in accordance with that, okay, now we know what the concern is. Is it permanent or is it temporary? Meaning, is it something that's going to get better? Okay. And we talk about this later in the slides, but I'm going to say it right now because we talk so much about guardianship as being permanent. There's really no such thing as a permanent guardian because every guardianship has to be renewed. It has to be proven that it's still necessary on an annual basis. So things can change. Even when you obtain a permanent guardianship over somebody, you have to prove to the court annually that it's still necessary. So it's nothing is truly forever without any work continuing to be done on it. So then we come into what other resources are available. Do we really need to get guardianship because someone is so incapable of being able to make their own decisions and think through those things that are important, medical decisions, school, work, home, where they're going to live, all of these things? Or are there other resources that can help? Aside from legal documents that can be put into place, are there therapies that can help? Are there assistants that can help? Are you able to help walk them through things? So there's a lot that goes into that, which does kind of connect into that team that we talked about earlier. Again, those are going to be you as parent, sibling, caretaker. Then you've got, again, teachers, counselors, doctors, etc. And then I mentioned these earlier. The biggest things in looking at that concern are, what are the person's actual capabilities? What are their limitations? And the biggest thing being capacity. Okay, what is a doctor going to say about their capacity level? So there are a few types of guardianship, and this is just a basic rundown. So the first thing we have in Texas, and if you are not in Texas, everything we talk about today is from the perspective of Texas law. So different states use different terminology, but here in Texas, the terminology that we use is a guardian of the person and a guardian of the estate. In a lot of states, you'll see the term conservatorship. That is more so used for what we refer to as a guardian of the estate. Many states, a guardian is what we refer to as a guardian of the person, and a conservator is what we refer to as a guardian of the estate. It basically is just a split. Guardian of the person, that's who's going to manage the personal stuff, medical decisions, housing decisions, all of the general things that you do as an individual or as a parent, those basic things that you handle for your child. Whereas the guardianship or the guardian of the estate, that's for money. If the individual who needs a guardian has assets, if they have a house, many times with a lot of my clients, this is not the case because we have younger children who are turning 18. But if, let's say, you're trying to get guardianship of a parent or an adult sibling who maybe has worked and then had something happen where now there's an incapacity, so they have money, they have bank accounts, they have retirement accounts, they've got a house, that's going to require a guardianship of the estate. Frankly, when we can avoid becoming a guardian of the estate, most attorneys are going to advise that we want to try to avoid it, but sometimes it's unavoidable. And then I mentioned permanent guardianship earlier. There are temporary guardianships. That's really not the focus of our conversation today. Temporary guardianships are more so things that are obtained in emergency situations. So we're going to kind of put that to the side, and most of today's focus is going to be more on your permanent guardianships. So we then have this concept of a full versus a partial guardianship. All that means is that a full guardianship means that as the person trying to obtain guardianship over the other person, and to be frank, the terminology that we have to use under the law, I don't particularly love it, and I know a lot of people don't love it, but we have to use that terminology. So you have the applicant who is trying to get guardianship, and what the law refers to as the ward. So the individual that you're trying to get guardianship over. So I'm, for the purpose of our conversation today, I'm probably going to continue to use the word child. I understand, and I know you understand, they are legally adults, but I just prefer to use that nomenclature. So with a full guardianship, what you're doing is you are saying, I need to have full authority. So everything in the law that allows you to have guardianship over, which what that means is that you are taking over these rights for the child. Okay. So some of those things are listed here: the right to vote, the right to hold a license, the right to make residential decisions, medical decisions, marital rights, managing financial matters. There are some financial matters that can be handled by a guardian of the person, and we'll kind of get into that a little bit later. But the biggest one for the vast majority of my clients come down to two things: medical, school. Okay. And of course, those other ones that kind of get included in their housing and whatnot. But again, this is where I pointed out earlier, that even with a permanent guardian, it is not necessarily permanent, because if the situation improves and it's no longer necessary in the future, you are going to bring that information to the court and they're going to say, great, we don't need to continue this guardianship. The individual is going to get all of those rights back and they can go on about their life as they need to, maybe with some other supports and services that might be available to help them at that point. So that's always a goal for most courts. So let's kind of talk about guardianship of the person in particular and what that looks like and the things that are required. So a guardian of the person, simply said, deals with the physical well-being and the body of the individual. So again, that goes back to the things that we were talking about earlier. So all of those things that you generally do as a parent, you're continuing to do past the age of 18. With a guardian of the person, I always say may here because it is possible depending upon where you are located. And again, this is all Texas based. So in some counties in Texas, there might not be a requirement of any bond. Most counties have a requirement for some form of bond. So to give you some examples, on one end, I am in Austin, Travis County. We have a great probate court here, and Judge Herman has set pretty well-known rules, but the way that the courts work here in Travis County and in many other counties is that there's a requirement for what we know as a surety bond. So what a bond is it's your posting either, sometimes it's a cash bond, Travis County it's a surety bond, kind of like an insurance policy of a set dollar amount, so that there's some money there in case something goes wrong, essentially. So the way that it works here in Travis County, it's a surety bond. It's a $13,000 straight cash, or excuse me, surety bond. And that's just something that's purchased through an insurance company. But then in other counties, for example, Williamson County, I typically have, $100 or $200 cash bond for parents, but that's going to depend on the circumstances. It's going to depend on the county, the judge, and the personal circumstances to your case. There are some counties that I've been in where there's been no bond required at all. But that is very, very rare. Guardian of the estate is an entirely different subject matter. Now, you do have to meet criteria. It's interesting when we're in a hearing, it always kind of makes my clients laugh a little bit because we have to prove to the court. And one of the questions that I always have to ask them is, are you qualified and not disqualified from serving as guardian? And it kind of makes people giggle a little bit because it's just an odd question to have to ask. But essentially, there are qualifications in order to be guardian in terms of age, capacity, kinship, and some other things we're going to get into later in terms of things that could disqualify you from acting as guardian. But as guardian, one of the key things that I always like to make sure that my clients are aware of, not just when we're actually trying to get guardianship, but with a lot of my estate planning clients who have special needs children, when we're talking about plans for the future, is that you have what we refer to as physical possession, but it's more about the ability to establish where the ward lives. A question I get a lot from estate planning and special needs planning clients is, let's say this is later on, and they're saying, well, when something happens to us, maybe John's sister is going to be the guardian, which we'll have a whole nother conversation about that, but let's go with that for now. But John's sister Sally has a full life and she's in school and she's gonna be a doctor or a lawyer or whatnot, and she may not be able to have him in her home. What does that mean? That she can't be guardian? And that doesn't mean that. So just because you are the guardian of somebody does not mean that they have to live in your home. It means that you are responsible for their well-being and deciding where that individual will live. But you do have an overriding duty to provide the care, supervision, support, well-being of that individual.
Melissa, we do have a question from Robert. He's saying, assume that the ward can pay the costs associated with the bond. Does the bond depend on the ward's assets?
So with guardian of the estate, yes, it does. So this conversation right now that we were just touching on is strictly for guardian of the person. When we're only dealing with a guardian of the person, it's generally going to be a set, like I said, in some of the larger counties, the $13,000 surety bond, or in some other counties, a cash bond of relatively minimal value. But when dealing with guardian of the estate, that bond is going to be typically a lot larger, and it is based on the amount of assets in the estate of the individual. So just two different scenarios. Now, final things here, when you are a guardian of the person, you are responsible for providing annual reports to the court, and there will be a court investigator in most cases, or a visitor in some, that is appointed to come and check in on the individual from time to time once the guardianship is established. So coming back to the other side of things with the question that was just asked, guardian of the estate, that is where the financial bond is going to be a little bit more complicated. There is going to be a larger bond required more often than not, but it does highly depend on the assets that are being managed under the guardianship. And there are ways to avoid guardianship of the estate depending on the circumstances. But this kind of gives you a little bit of a rundown of the requirements for a guardian of the estate. You have to inventory assets, things have to be appraised, you have to have a list of claims, you do have to take an oath. Now, as guardian of the person, you take an oath when you're approved as well, but the bond here, again, is going to be higher than in a guardian of the person only. The other thing is that a guardian of the person and the guardian of the estate do not have to be the same person, and many times are not the same person. So always kind of keep that in mind if you're dealing with a situation where it's an older child, if it's a sibling, if it's a parent, someone who has assets that you're dealing with. There are additional things that go into considering that and who those people might be, and also who the court will want to manage those assets. Now, this again, kind of continuing on in the guardianship of the estate side of things. You do have to file the application. The thing that we always say, and why sometimes people ask us as attorneys, why do we want to avoid the guardian of the estate if we're doing guardian of the person? And a lot of it has to do with the involvement of you having to be involved in the court more often, and everything that is involved in that. And again, in the vast majority of the guardianship cases that I work with, there is no need for a guardian of the estate because we can avoid it either because there are no assets or the assets that the individual has are very minimal, or because you can do special needs trusts, you can do court trusts, you can file things with the register. So there's a lot of things that can be done to avoid it depending on the situation. But the issue with guardian of the estate compared to guardian of the person is guardian of the person, once you are approved and you have your letters, you have to report to the court annually on the well-being of the individual, but you don't have to go to the court for permission on everything. You're not doing monthly allowances. You're not having to go for all of the things that you need to go for a guardian of the estate. If there is an estate, it is much more complicated. And many times guardians of the estate that would be appointed by a court are going to be more professionals, or they're going to they're going to want you to show that you have the ability to manage the assets. Every situation is different. So those are things that you want to talk about with your attorney if there is an actual estate at play. Now let's kind of talk about the process of when it
Just
comes to.
a quick
Yep.
question on that. Robert is asking, doesn't the power of attorney cover most of the estate issues?
I'm sorry, doesn't the power of attorney,
Cover most of the estate issues.
if there is a power of attorney? That's the key. In a lot of these situations, if you're trying to get guardianship, there is no power of attorney. And a power of attorney is one of those lesser restrictive alternatives that in some situations is very helpful. And it's great if we can do those because we don't want to do guardianship if we can avoid it. I know there are always people who have seen, the Britney Spears and all of these other things that you've seen on Netflix and things like that about guardianships. Courts do not want to give guardianships unless it is absolutely necessary. That has been my experience working in Central Texas. I have not seen a situation where a judge is really wanting to do a guardianship unless it's absolutely necessary. And if we have a power of attorney, that is one of those factors that shows that, well, a guardianship may not be necessary because we have the power of attorney and the person that's acting as power of attorney is perfectly capable of managing things and doing a fine job. Now, there can certainly be scenarios where someone has signed a power of attorney and the person that was designated is not doing a fine job. And maybe we need to get guardianship because that person is not doing the job that they need to be doing and embezzling funds or doing things in bad faith. But generally speaking, if there is a financial power of attorney in place or there is a trust in place that there is a trustee, then the assets are managed outside of a guardianship, and that's great. So let's kind of walk through what the process of obtaining a guardianship looks like. So you do have to file an application for guardian with the court, and depending upon the county that you're in, you may be in a statutory probate court or you might be in a county court. Just depends on the size of the county that you're in. You can actually submit the application for guardianship starting 6 months prior to the 18th birthday. And I know for some people that might seem like a very long time, but here's what I can tell you. Even with an uncontested guardianship, it can take 4 to 6 months to get a hearing because there's work that has to be done up until that point. You will not be able to do a hearing until the individual actually turns 18, but it is a good idea to start thinking about this process. Usually about 8 months prior to the birthday, you can start thinking through things. So let's walk through the other requirements here. So depending upon the disability, there's two main things, one or the other, that you are going to utilize as the initiating factor for getting the guardianship. If it is an intellectual disability, you can have an intellectual disability report that has been completed no earlier than 2 years prior to the individual turning 18. I have had those been used in the past. And then the other way is physician certificates. So for a lot of our clients who, let's say it is a neurological disorder or there's Down syndrome, I've had cerebral palsy clients, I've had clients with, plenty with severe autism. A lot of the times those are going to be physician certificates, which is a 4-page document or so that is given to your child's doctor. They complete it, and most of the impetus of the guardianship is going to come from there. Okay. That physician certificate can be completed 120 days prior to the filing date. So not prior to the 18th birthday, prior to the filing date. So if you put in an application that 6 months prior to the 18th birthday, that physician certificate can be essentially 4 months prior to that. Okay. Now, once we have that, the attorney that you hire completes the application. That application is then submitted to the court, and the clerk is going to issue citation. So this is how this works, is that there are certain people that need to be served. Okay. Now you can get most of those people to waive service if they are agreeable. So to give you a general idea in kind of something that is in most cases. So first and foremost, this always kind of throws my clients off a little bit. You are the person putting in the application as mom and dad, but you also need to sign a waiver saying you don't need a constable to come and serve you process for the application having been submitted. If there are adult siblings, we usually want them to sign a waiver or they are going to have to be served by a constable. If there are spouses, if your child is living in a residential facility, the administrator of that facility would be notified. So these are people that you want to have sign waivers in advance if we can get them to do so, because then that eliminates the necessity for having them served. The only person who does have to be served and will not be able to sign a waiver is the person you're trying to get guardianship over. So if you're trying to get guardianship over your son is going to have to be served by a constable. Most, in my experience, are well equipped to handle the situation, and everybody's different. I was with a client the other day who said, their child loves all police officers. There was no concern about it whatsoever. And then I have other clients who their child would be a little bit less amenable to having that situation occur. So we try to be really careful. Most of the people who do this kind of service do try to be a little bit more sensitive to how they're doing it. But they do need to physically hand that paperwork to the individual that you are trying to get guardianship over. They cannot waive. Once that all occurs, a court is going to appoint what is called an attorney ad litem. So when you hire an attorney to help you with guardianship, that attorney represents you. A court appointed ad litem is going to be appointed for your child. Okay. Depending on the county that you're in, there may be a pre-deposit with the court that the ad litem is paid out of. There may be fees that are paid after the guardianship is over. That all depends on where you are and how that particular court deals with things. And then once all of that occurs, the ad litem is appointed. What's going to happen is the ad litem is going to meet with you. They're going to meet with the individual they represent. If there are those other individuals that I mentioned earlier that would need
Melissa, I think you're frozen. Let's give her a minute to get back on. There you go. You need to unmute.
I apologize. Okay. So forgive me for a little technical glitch there, but we are back up and running. So the next situation that we're going to get into is who can actually act as a guardian. And this gives you kind of the hierarchy in the statute as to who can act. If the individual is married, it's going to start with spouse. If not, as in most of my situations, most of the cases that I work with, parents, adult siblings, grandparents, some situations step parents. And then I mentioned earlier the issue of having to be qualified, not disqualified from serving. These are some of the things that would disqualify someone from serving. So if someone is incapacitated themselves, if they are a minor, of course, they cannot serve as a guardian. Generally speaking, the way that we have explained this be in the past is most people will say, well, if you're a felon, you can't be a guardian. That's not exactly the way that the law is written. It would be the actual verbiage is if you have a history of notoriously bad conduct. So just the fact that someone might have a criminal record does not necessarily automatically mean they are not able to serve as a guardian. It's going to be looked at by the judge as to what is appropriate and what's not appropriate in that scenario. Now, let's talk about ways that we can avoid, in some cases, having to go the route of getting a guardianship in place. This is always, from my perspective as a special needs practitioner, where I would prefer that we're able to go when we are able to utilize these tools. And I think it was Robert who was asking some questions earlier about powers of attorney, and that's exactly what this is for. If we have an individual who has at least the ability to understand what it means to be signing a durable or a statutory power of attorney, financial power of attorney, a medical power of attorney. So they have a base, they're able to understand that I am signing a contract to allow this person who I'm naming, whether that's mom, dad, sibling, best friend, whoever that is, if the individual has the ability to understand what it means that I have assets, I have things that need to be managed, or on the medical side of things, there are medical decisions that may need to be made for me in the event I cannot make them for myself, and they understand what they're signing, they can sign these documents, and then we don't generally need to go to a guardianship, which is always the better alternative. There are some things that go along with that. So HIPAA authorizations are going to allow the doctors to speak with more people, not just the medical powers of attorney, medical directives, what most people commonly kind of refer to as living wills, so life support documentation. There's declarations of mental health treatment, particularly for people who might have some of those health concerns. Those are all on the kind of paperwork side of things. We're going to get into supported decision-making agreements in a little bit more detail in a moment. But before we dive into that, on the financial side of things, some other things that can be done. Are there joint accounts? Okay. Meaning if we're talking about your daughter or your son and they're about to turn 18, they have money, but are all of those accounts in joint accounts that you are on as a joint owner? So you already have a way of helping them manage that. Or if they are collecting Social Security, are you the rep payee for Social Security? And then there are management trusts, special needs trusts. These are all ways that if there are assets that are coming into the picture, and let's say your child is 17 and you're trying to get guardianship, but you don't want to have to do guardian of the estate, can we use some of these? And in many situations, we can. I have a client recently that I had a guardianship for. That there was an account that we ended up putting into a first party special needs trust prior to the trying to get guardianship and attempting to get Social Security when that child turned 18. So these are all things that you would discuss with your own attorney as to what makes sense for you in the personal circumstances that you have. Katie's Law, community administrators, geriatric care managers, those things tend to be they're on the elderly side of things. They are included here, but generally this presentation is geared more towards the younger set of individuals. So the biggest thing that I find people have questions about when talking about guardianship, that they've heard this, but they might not know exactly so much about it, or they don't understand what it really is, are these supported decision-making agreements. And these, I will be very honest, I am the first person to admit when I am wrong. And when they first came out, I went through a few years of, I'm not so sure this is going to be great for anybody. I don't see the benefit of this. And I was wrong. Okay. I find that these have been super helpful for many of my clients. To give an example of a situation where this is really helpful. I've had clients with autism. I have a client that has cerebral palsy, that is actually quite bright, but difficult for other people to understand. And not quite at the point where he or she, in various situations, is really able to thoroughly connect all of the dots to be able to make informed decisions about things. That is where these come in so handy. Now, the key with supported decision making agreements is that you never just do a supported decision making agreement. I always suggest that these are done in conjunction with those other alternatives that we talked about earlier, the powers of attorney, the HIPAA authorization. You do need to sign a HIPAA authorization when signing a supported decision-making agreement. So let me explain exactly what the supported decision-making agreement is. It is a contract, okay? But it is a type of contract that the law does not require the exact same level of capacity as what we typically think of for contracts. Contractual capacity, in the general sense of things, is actually one of the highest levels of capacity that someone might have to have. But courts have deemed that for these particular agreements, and that's probably why we call it an agreement, not a contract, but in the way that we colloquially think of a contract, it is a contract. You are making an agreement with another person. The level of capacity that's necessary to sign these is much lower than a true capacity, contractual capacity level. But this is an agreement that is signed by the individual, so your child, and the person who might otherwise have guardianship that we're avoiding. So mom, dad, whomever that might be. And the goal of this is that the individual, so sometimes it's easier to have names. So Sally is signing the supported decision-making agreement for her mom and dad to help her be able to make these decisions. The key with a supported decision-making agreement, it does not allow mom and dad to make Sally's decisions for her, meaning they are not stepping over her to make the decision. Your role is that you are there to help guide Sally to make the best decision for herself. Okay. So that's why it's defined here kind of, it's a process of supporting and accommodating the adult with a disability to make those decisions. You, again, do need to have a couple of things that go along with this. There is a HIPAA authorization. The supported decision-making agreement, generally with doctors and third parties, is not going to work in and of itself. I've had clients that have run into this when they've just done supported decision-making agreements kind of on the fly. And then they go to the doctor and the doctor won't speak to them. You need a HIPAA authorization signed in conjunction with the supported decision-making agreement. The other thing that you will need if your child is still of school age and you're still dealing with schools is there is an educational form that needs to be signed as well to be given to the school along with this document. But anybody over the age of 18 can sign one of these, okay? Again, the level of capacity. Now this is, forgive me, the verbiage on the slide is a little bit older, but it generally speaking is not defined, but we have had decisions in the recent past that have said it is not to the same level of contractual capacity. It is a general it is a lower level of capacity necessary to sign these. It is very different than the medical power of attorney and the financial power of attorney. So this is where the supported decision-making agreement becomes so helpful, because with a durable power of attorney that any of us might sign, like I sign it, you as an adult sign it, it's just a normal part of our estate plans. A durable power of attorney allows someone to help you with your financial decision-making, help with your assets, manage estate issues, regardless of whether that you are incapacitated or not. That's what a true durable power of attorney does. It is effective the minute that you sign it. That's great on the financial side for these individuals that have these disabilities but need someone to help them on the finance. Medical powers of attorney are different. Medical powers of attorney only allow someone to step in and make a decision for you when you cannot make it for yourself. A doctor is not going to let mom make the decision for Sally just because mom wants to make it and there's a medical power of attorney saying she's a medical power of attorney. But with the supported decision-making agreement, that is going to allow mom to gather all the information and become essentially like the point person to gather that information and help Sally, help her weed through what that looks like so that Sally and mom or mom and dad or whomever is on that agreement can discuss it and allow Sally to make the best decision for her. So it takes some getting used to if you're not familiar with these. And like I said, even personally, I went through a brief period of time where I wasn't sold on them yet, but I have seen it be very, very helpful for many of my clients when we're trying to avoid guardianship.
Melissa, Mary is asking regarding the supportive decision-making agreement. If it's provided to parents and families in special education during the IEP or ARD process, does it have any other impact or implications in any other area such as banking and medical, et cetera?
Just to confirm, those appear to be two separate questions. I don't know if every school is going to provide these. I don't believe that they are, because not everybody can actually utilize them. Now, is it possible that you will get it from someone? Yes, there are standard forms out there that are available that people can find. In regards to the second question, and can it be used for finance and things like that? It is a decision-making document. It is not a management document. So it is not the same as a financial power of attorney. That's why I say, generally speaking, when we as attorneys are doing these, we are doing them in conjunction with those other powers of attorney, because it's the durable power of attorney that's going to allow for someone to actually deal with assets and whatnot. But it can be used to help Sally in making financial decisions about, for example, a job, where to work, or where to go to school, where to live, all of those things. So it's not a financial management document. That's the durable power of attorney. But it does allow you to gather information to help Sally in making some of those things that are kind of ancillary financial decision-making things. But this also gives you a rundown of what these are used for. And again, the key here to that financial question and other, it doesn't create a fiduciary relationship, meaning there is no, it is not the same as being a guardian. It is not the same as being the durable power of attorney. When you have a fiduciary relationship, you have an obligation to act in the best interest of the individual. That's not to say that you should not act in the best interest of the individual regardless, but it is not legally a fiduciary relationship, but it is a confidential relationship. So all of that information that is learned by virtue of having this in place, you could be held for breach if you were to share that information with other individuals that are not pertinent to the individual, to Sally in our example. But again, the key, and I know I've probably nailed this point home already, but it does not allow you to make decisions for the individual. It is there to help them make the right decisions for themselves. So here are some things to think about, okay? This is why we have this conversation with people about, what's going to make the most sense, okay? When your child turns 18, and I know this says in the state of Texas, but this is going to be the case anywhere, the individual is an adult. Legally speaking, you no longer have the authority to make decisions for them, okay? You can no longer go to the hospital and tell the doctor to do something or tell them not to do something. Or in many cases, you can't even call and make an appointment. I can speak to personal on that. I mean, even if you don't have a disability, for those of us who might have started college a little bit younger, it's a little jarring the first time you try to have your mom make an appointment and then you realize you can't. So totally different issue. You might want to think about your more typical kids also having powers of attorney, HIPAA authorizations in place as they're going off to school in particular. But for your children who do have disabilities or some special needs, these things are really important, because you can't handle these things for them without one of these things in place, whether it's guardianship or alternatives, but they also don't have the ability to do it for themselves. When I didn't want to make the doctor's appointment at 17, or excuse me, at 18, my freshman year in college, I could. I didn't want to, but I could. But if I had a disability, I could not. And that's why these things are important, okay? But it's recognizing that as soon as that individual turns 18, they're their own person. They can decide their own life's course under the law. But it's not always in their best interest to be able to do that, depending on the circumstances. So that's your child's side. Again, there are some points on here about if you are dealing with an elderly parent, and some of you might be dealing with it from both sides. We are, you might be in that sandwich generation where you're taking care of kids and elderly mom or dad, and you might be getting these issues on both sides of things. So it's important to think about that stuff. So then, what are the things that you have available to you? Okay. So first, who is your support group? Okay. So make sure that you are continuing to surround yourself with people that you can talk to, people who understand what you're going through. There's a lot of great groups outside of just attending these webinars for various situations. You know, there's all sorts of groups out there and support groups that you can become involved in. With your kids, like I said, if you are thinking that guardianship is going to be a necessity as your kids get older and when they turn 18, start having those conversations with the professionals around you early. Okay. Because I have had clients that have come in for estate planning and their child is 14 years old and they are convinced that they need a guardianship. And after a short conversation and learning a little bit about their child, I can tell them you're probably not going to need it. We're probably going to be able to do one of these alternatives. And I've had it happen the other way. So it's just important that you're, thinking about those things, that you're doing what you're doing now. You're watching the seminars, you're attending the seminars to learn, because that's going to prepare you for as you get to that 17 age where you're really going to have to start putting some things into action at that point. So think about it early for your own purposes. Think about your own estate planning. If you have a child with special needs, have you done your estate planning? Do you have the right special needs trusts in place if you need a special needs trust? Have you executed guardianship declarations? So you're designating who's going to take care of the kids when something happens to you. And then again, consider the fact that, like I said earlier, with your children, when they turn 18, they may not need guardian. You might not need a guardianship. You might be able to get away with powers of attorney, supported decision-making agreements, and some of those lesser restrictive alternatives. So we've got quite a bit of time for questions for any of you who might have questions. I know there were a few questions that were asked yesterday. Meredith, did you see any other questions?
No, there's nothing more coming in here, so we should probably cover some that were submitted.
So off the top of my head, and forgive me, I'm not sure if you have some of those in front of you. I know that there was one particular question I remember seeing about special needs trusts and I think powers of attorney.
Yes, go ahead. And I have just pulled them up here so I can be more helpful.
Okay. If you don't mind, can you remind me exactly what that question was?
Tell me the context again. What was the subject? I am looking at
There was
the,
a question, and I think it was towards the bottom of the list actually, to do with special needs trust and power of attorney. And maybe it was asking what the difference was or
yes. Julia had asked, what is the difference between special needs trust and power of attorney, how it works, pros and cons?
So special needs trusts are a very different thing from powers of attorney. So a power of attorney is essentially a permission slip. A power of attorney is what, I write that my husband or my father or my sister or whomever can act as my power of attorney and they can manage things for me as needed. Okay. A special needs trust is a trust that is done specifically to protect assets so that they are available for an individual who may receive Medicaid or SSI, what we call means tested benefits, while allowing them to have access to the money to benefit them, but not reduce or completely eliminate the benefits that they get from Medicaid and Social Security. There are a lot of different types of special needs trusts, and there is a whole webinar that we do on special needs trusts in particular that I would suggest if you have questions on special needs trusts that you sign up for the next one of those webinars, or I know that we have some previous ones that are on the YouTube channel, and those can be really, really helpful. But generally speaking, if we just think about it real simply with a special needs trust, there are first party special needs trust and third party special needs trusts. So a first party special needs trust is one that is created with the individual who receives Medicaid's money. So an example of that would be if, let's say, my child was in an accident where there was a lawsuit and a settlement. That is my child's money, but now my child is permanently disabled and going to need Medicaid and Social Security benefits. A first party trust is created for that money that is coming from the settlement so that it can be used to provide for my child's needs, but still allow my child to get Medicaid benefits in the future. With a first party trust, the key difference in the long run on those two things, aside from whose money goes into it, is that first party trusts have what we call a Medicaid payback provision. Third party trusts do not. Third party special needs trust would be more of, I am doing my estate planning and I am putting money aside for my child with special needs, and it's going to go to a third party special needs trust. Same reason, to be able to use it for his or her benefit for the rest of their life, not lose any Medicaid benefits. But then that money, when my child eventually passes away, whatever's left gets to go to his siblings or whoever I designate. It doesn't go back to the state. Now I am going to come back because I noticed there was some some chats that got put in here as we were talking.
Yeah.
Now, there is a note from Paige saying that one of the issues that they see is that a power of attorney can be revoked. Yes, a power of attorney can be revoked and it can be assigned to another person. A guardianship cannot as easily be revoked. However, if an individual has the actual capacity to sign a power of attorney, okay, you need to really consider and think long and hard as to whether a guardianship is actually necessary. Now, that being said, I have seen it happen where people have had people sign powers of attorney when the individual did not have capacity. That is a completely different scenario. So it's just that thinking about just from the perspective of a power of attorney can be revoked and a guardianship cannot is not the general way that we're going to look at things, because there's a lot more that goes into it. But if we know that someone has the capacity to be signing powers of attorney, we're going to think long and hard as to whether or not a guardianship is the right option, because we're going to have to prove to the court that that power of attorney is not sufficient. So it's just there's more that goes into it than just the fact that a power of attorney can be revoked.
Okay, and
Now,
Megan is asking regarding the guardianship preparation is 6 months prior. What about, sorry, I just lost it there. Here we go. It just moved on me. What about the SDMA? How
so
many months?
so let me forgive me. Guardianship. Okay, so the supported decision making agreement. Forgive me, I'm so sorry that y'all are having to deal with my voice today, but with the supported decision making agreement, that cannot be signed until your child has turned 18, because that is an agreement that has to be signed by someone who has legal capacity. Legal capacity is only over the age of 18. Someone under the age of 18 cannot sign a supported decision making agreement. But it's not, guardianship is a legal process involving the court. It takes months to go through the entire process, generally speaking. Supported decision making agreements are they're legal documents that you're going to meet with an attorney if you, in some situations, or prepare if you have them. It's nowhere near the same time frame that you're worried about things taking too long. But no, you do have to be 18 before you can sign the supported decision making agreement.
Brooke is asking an important question. How do we protect our child legally and financially if they hurt someone? And do we need to protect ourselves as well?
So this, unfortunately, this is a really difficult question. Now, here's what I will say about guardianship is that, generally speaking, so long as you are not negligent in your care of the individual, you are not going to be held responsible personally for the wrongdoings of the person that you have guardianship over. Um, a lot of this has to do with how, and I know it's a really difficult question, and I don't know that I have the best answer for anyone, truthfully. It's no different than just being a parent. None of us are perfect and none of us have all the answers, but you just have to do your best to protect your child. And unfortunately, there are some circumstances that we just don't have all of the answers to. But that is something that needs to be handled. Now, what I will say is that if you have a guardianship over the individual, and there were a criminal situation to arise, you do have the rights to be notified, step in and all of that. But unfortunately, if there's not a whole lot that we can tell you in regards to that scenario.
Okay.
The next question that I see here is that there's a question about, is it necessary to have one of these options if a child is nonverbal, and it's noted that they cannot make decisions? If it's very clear that these alternates are not an available option to somebody, then no, they're not an available option. You're not going to attempt to do them. And the court would not require that. But we do need to show when you're getting the guardianship. And again, this goes back to that physician's certificate and what the doctors are saying, because a lot of that's going to come down to what the doctors say. If the doctor is saying very clearly that this individual does not have the capacity to be making decisions, signing these documents, then yes, we're going to be having to get a guardianship and we're not going to have any alternates available to us. And then kind of with that, there was a question about applying for Social Security. You can still apply for Social Security. And generally speaking, when applying as a guardian of the person, part of that order, the judge will generally, if you just ask them to, and sometimes you don't even have to ask them, say that you would be the default rep payee for Social Security purposes. But the guardianship allows you to do those things.
Okay, and Brooke just put a question, do we need to get them an ID?
I would suggest that you do have an ID and it doesn't hurt to make that notation.
Okay.
That she's asking about here about marking it, that they're unable to answer questions. The other thing that you can do is you can also keep a card. It doesn't even need to be fancy. You can keep a card with the ID. If your child has been, I'm going to use the term trained, but if your child knows what they need to keep on them and they're keeping the ID on them and keeping a card with it that indicates that, now, of course, I can't make any guarantees about every single individual that they might come into contact to, but it definitely helps that you are making those third parties, whether it's a police officer or someone else, that you're making them aware that that is an issue.
Okay. And Rachel is saying we applied for a passport
Yeah.
for my special needs daughter, and they give you a passport card, which is very useful.
And then I will come back because there was a question about the supported decision-making agreement and the decision to marry. Again, with the supported decision-making agreement, it is not something that is allowing you to make decisions for your child. So if your child makes a decision to get married, there's not a whole lot you can do about it. It is
Okay.
not guardianship.
We're getting close to the end. Let's do one that was submitted ahead of time. Myrna had asked, what about my son who is already 18 and older? Should I move forward with these decisions?
Yes, if you feel that it's necessary, you don't have to do the guardianship just when they turn 18. I've had plenty of clients that have tried to go along to get along as much as they can. And we've applied for guardianship later on when they kind of hit the wall, if you will, because you will run into scenarios where, the doctors that you've worked with the whole life of your child are going to continue to work with you. That's not all of them. They legally have obligations, but some will continue to do it. So if you haven't done it yet, but you're thinking that you still need to, do not let the fact that your child is now 19 or 20 or whatnot make you feel like you can't do it. You can do it at any age. In fact, I had a guardianship a few years ago that the individual's child was 22. So it does not mean that you can't do it if you don't do it exactly when they turn 18.
Good. Do you have any suggestions of attorneys in the Houston area?
What I would suggest if you are outside of the Austin area, I will put some websites into the chat that people can share, and maybe Meredith, y'all can share that later with individuals.
Absolutely. I would suggest you could make an appointment with us for a consultation. I know Allison and Michelle and Andy we have a referral list of folks that we have relationships with and we trust. So we might be able to direct you to that person as well. So I guess we'll need to wrap this up. If you asked a question and it didn't get answered, I'll be reaching out to everyone and I can point them in your direction, Melissa. We certainly appreciate this presentation. And Allison is sorry she was not here today. She appreciates the opportunity of presenting to you, and she always offers a lovely 45-minute free conversation to get you started and answer many questions. So we'll end it there, and we thank you so much for being here with us today. Thank you.
You all.